invitees and participants, please sit. Before we officially start this event, allow us to pray in accordance with our belief respectively. To the related committee may help to lead the prayer.
Before we start today's event, we shall pray according to our own beliefs. However, on this occasion, allow us to deliver it in Hindu. And for the other religions, we respectfully ask you to adjust it. Om Swastiastu, Om Awiganamastu Namasidam. Om Adityasya Pramojote Rakta Teja Namostute Sweta Pankaja Madhyaste Bhaskaraya Namostute Om Pranamya Bhaskara Dewa Sarva Krisawinasana Pranamya Ditya Siwarta Bukti Mukti Wara Prada Om Rang Reksa Pramasiwa Raditya Yanama Swaha Om Yang Widiwasa, the Almighty. We worship you as our Son. Lead us on this year's event, precisely on Sunday, August 29th, 2021, with the SCIL International Seminar, disclosing the relevance of data theft as cybercrime and its potential civilian costs from international law perspective. We pray to you for the smoothness of this event. Guide us the right path and bring us out from darkness into the light. Thus, we could be hindered from any wrongfulness. Om Yang Widiwasa, the most gracious. We only pray to you. Please give us your blessing and protect us from any harm that might come on our way. Om Yang Widiwasa, the most merciful. Forgive us from our sins, mistakes, and wrongdoings. Om Yang Widiwasa, please grant our prayers. Om Mano Graha Mano Hara Dewa Data Anugrahaka Ya Racana Masarwa Pujana Nama Sarwa Nugrahaka Om Dirgayu Nirviganam Sukhavardi Nugrahaka Om Sriyam Bhavantu Sukham Bhavantu Purnam Bhavantu Om Santi 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 Om.
Thank you to the committee who led the prayer. The next agenda continues with a report from the project officer of SCIL International Seminar 2021, Mr. Gede Adi Widyatmika. So, Mr. Adi, the screen is yours.
Om Swastiastu, Assalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya, and may peace be upon us. The Honorable Mr. Dr. Putu Gede Arya Sumartayasa SIM Hum, as the Dean of Law Faculty of Udayana University, which in this occasion represented by the Vice Dean, the First of Law Faculty, Udayana University. The Honorable Head of International Law Lecture, the Honorable Speaker of ICIL International Seminar 2021, Mr. Sebastian Lafrance, Mr. Imade Budi Arsike, Miss Alia Yovira, Miss Made Ananda Bella Cahyani, the Honorable Advising Lecturer of ICIL, Miss Cokorda Istri Diah Widyantari Pratnya Dewi, and all the distinguished invitees and our beloved participants of this event. First of all, I would like to thank God, the Almighty, who has showed His mercy and grace on all of us, so that we can gather today in good health. I express my gratitude and appreciation to all colleges who have participated in learning, discussing with us in this forum. As we know, in this era of globalization development, and at the same time, seeing the COVID-19 pandemic situation, all activities carried out by the community are limited and being done from home. We often use social media and the internet as a shortcut. Moreover, incident and case regarding data theft that occur in cyberspace is one of the crimes that is very detrimental. Therefore, through SCIL, we conducted the international seminar with them disclosing the relevance of data theft as cybercrime and its potentially civilian costs from international law perspective. This event has been prepared optimally for 4 months, since May until August, with lot of struggle and sacrifice from the committees. And finally, we came to this day with more than 500 participants, not only from national, but also from the international scope. We really hope through this event, all of the participants gain new knowledge and information regarding data theft as cybercrime and can be aware from the consequence of it. I would like to thank the people who have worked hard and taken their time to fill their duties and responsibilities to organize and make this event a success. And also to the functionaries of SCIL who also never stop providing direction and support for us. We also thank our speaker today who are willing to share their knowledge with us. Last but not least, I say thank you and apologize in my delivery. There are things that are less pleasing. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya, and may peace be upon us. Student community for international law, we are smart and low profile. Thank you.
Thank you to the project officer. Now, we will be hearing the remarks from the President of Student Community for International Law, Ms. Made Ananda Bella Chayani. To Ms. Bella, this screen is yours.
Thank you, Damara. First of all, I would like to ensure that my voice is audible.
Yes, it's audible, Ms. Bella.
Thank you. Om Swastiastu. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya, and may peace be upon us. The Honorable Vice Dean the First, Faculty of Law of Udayana University, Ms. Dr. Desa Putu Dewi Kasih SHM Hum, the Honorable Speakers of SCIL International Seminar 2021, firstly, the Crown Counsel Prosecutor Public Prosecutions Service of Canada, Mr. Sebastian Lafrance, the Honorable Lecturer at Faculty of Law, Udayana University, Mr. Imade Budi Arsike, the Honorable Researcher at Institute for Policy Research and Advocacy, Ms. Alia Yovira Karunian, the Honorable Advising Lecturer
of Student Community for International Law, Faculty of Law, Universitas Udayana, Ms. Chokorda Istri Dia Widiantari Pratnya Dewi, SHMH, the Honorable Chairman of the Student Executive Board, Chairman of Student Representatives Council, and Chairman of all the student activity units within the Faculty of Law, Udayana University, the Honorable President of Student Communities outside of the Faculty of Law, Udayana University, or those who represent that I cannot mention one by one, as well as my beloved SCIL Functionaries Board, Committee Board of SCIL International Seminar, along with all of the participants who attend today's event. First of all, I would like to express my biggest gratitude to Ida Sang Yang Widiwasa. As for his grace and his light, we are able to gather here in SCIL International Seminar to witness and discuss about disclosing the relevance of data theft as cybercrime and its potential surveillance cost from international law perspective. This theme was raised in order to increase awareness related to crimes that are experienced by the society through cyberspace, especially data theft as cybercrime and the role of international law in overcoming this. Therefore, it is a great honor for Student Community for International Law to be able to have our great speakers in today's event, especially Mr. Sebastian Labrance, who is the counsel prosecutor in Canada, which is also one of the judges in the GSAP Global Rounds when I was competing against the University of Lantai. It is a great honor for me to be in a one forum with you. And also for the lecturer at Faculty of Law of Udayana University, Mr. Ibudi Arsiko, which is also always supporting SCIL from the very beginning, as well as one of our alumni of SCIL, Ms. Alia Yovira Karunian, which also always shows her support for SCIL. This international seminar is actually held annually by the Student Community for International Law. However, due to this COVID-19 pandemic, we have to hold this event virtually. Accordingly, I apologize for all the shortcomings and mistakes that might appear during this event, whether it is intentionally or unintentionally. Lastly, let me give my biggest gratitude and appreciation for the SCIL International Seminar Committee as well as my functionaries board, in which they have given their best contribution as well as dedication in holding this international seminar. That's all I can say. Allow me to close my remarks with Parama Santi. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya, and may peace be upon us. Student Community for International Law, we are smart and low profile. Thank you. I give it back to my fellow Damara.
Thank you, Ms. Bella. Now, we'll be hearing the opening remarks from the Dean of Law Faculty of Udayana University, Dr. Putu Gede Arya Sumartayasa SIMHUM, which in this occasion is represented by the Vice Dean the First of Law Faculty of Udayana University, Dr. Desa Putu Dewi Kasih SIMHUM. This greeting will also mark the opening of this event. To Mrs. Dewi Kasih, the screen is yours.
Thank you, Damara.
Yes, Mrs. Dewi Kasih.
Okay. Om Swastiastu. Assalamualaikum warahmatullahi wabarakatuh. Salam, Namo Buddhaya. May peace be upon us. Good morning. Allow me to deliver a remark on behalf of the Dean of Faculty Udayana University. Greeting to the honorable speakers, Mr. Sebastian Labrance, Crown Counsel Prosecutor Public Prosecution Service of Canada, Mr. Imade Budi Asika, lecturer of Faculty of Law, Udayana University, Ms. Alia Yofira Karunian, researcher at Institute for Policy Research and Advocacy, ALSAM, Ms. Made Ananda Bella Cahyani, President of Student Community for International Law, Faculty of Law, Udayana University, and to the Honorable Moderator, participants, and committee members of this webinar. First of all, the biggest gratitude I express to Ida Sang Yang Widiwasa, the Almighty God, for His grace and guidance, so that we are blessed with an abundance of health and pleasure to be able to gather on this occasion. In this midst of the current situation, which only relies on social media to interact, it causes many crimes to arise and a lot of people to be the victim of thereof. Crime modes and various data techniques are also becoming more varied in the arena of the emergence of crimes in cyberspace, which are not only transnational in nature, but also manifest in virtual actions. It shows that the role of international law in overcoming this matter needs to be known and applied. To find out from the perspective of international law, I'm grateful to know that Student Community for International Law has initiated a discussion forum by holding this international seminar, highlight disclosing the relevance of data theft as cybercrime and its potential civilians costs from international law perspective. I'm not that speakers to this seminar represent various backgrounds, including for law practitioner, researcher, lecturer, and student. In this regard, I would like to reiterate my sincere gratitude to Mr. Sebastian Lefrance, Mr. Imade Budi Arsika, Ms. Alia Yofira Karunian, and Ms. Made Ananda Bella Cahyani, who have generously committed to sharing time and knowledge with the audience. I'm expecting that this event can be useful, both theoretical and practical, and may success as it is planned. Besides, I hope that all participants who join this forum can listen to the presentation well and have active discussions to truly explore the theme discussed, so that later they can add to our insight and knowledge. Lastly, by giving this opening remark, I gladly announce that SCIL International Seminar 2021 is officially open. Thank you. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Salam Namo Buddhaya. May peace be upon us. Thank you.
Thank you for the opening speech.
Okay.
Thank you for the opening speech, Ms. Devakasi. By that, this event has officially opened, and we would like to remind the participants to mute the microphone and turn on the camera during the event. To begin the event today, we will immediately move to the lesson session, which will be guided by our moderator today. Hence, I will introduce him through his CV. His full name is Iko Mangdananjaya. From 2019 and to present, he has been studying in Faculty of Law, Udayana University. And for his organization background, he has been the Deputy Head of Academic Division Student Community for International Law and he was a member of teaching division in Sekolah Tanpa Gedung. Moving on his experiences, in 2020, he was the Master of Ceremony of Alpha LC Unit Legal Movie Discuss, and he was the Master of Ceremony for Student Community for International Law Election. Moving on his achievements, in 2017, he was both Best Oralist and the champion of National Law Debate Competition in Ubaya Law Fair. And in 2018, he was the champion of National Law Debate Competition in Pajajaran Lantai. Without any further ado, let's welcome our moderator today, Ikomang Dananjaya. To Dananjaya, the screen is yours.
Thank you, Damara, for the amazing introduction. Good day, everyone. Good morning from Bali. It is such a great honor for me, Ikomang Dananjaya, to moderate this online seminar thoroughly. Ladies and gentlemen, we all nowadays are very dependent upon digital platform, especially in this pandemic situation. Many sectors in our life have been transformed to be digital, be it education, work, financial, and even entertainment. We are likely to adapt to this as no other alternative exists. This circumstance potentially raises a threat for each of us. Our data, which is highly likely our privacy, is susceptible to be stolen and be a subject to a misapplication. With that, Student Community for International Law intended to conduct an eye-opening seminar under the theme, Disclosing the Relevance of Data Theft as Cybercrime and its Potential Civilian Costs from International Law Perspective. In the first part of our sharing session, joining with us two distinguished experts who will talk about international law aspect of data theft. However, before we jump into the sharing session, I'd like to remind all the participants to turn on their camera, yet still be conducive by turning off their microphone. I'd also like to inform that participants are allowed to ask questions to our speakers, even during the presentation, through the link provided by the committee in the Zoom chat box below. Thank you. Allow me to introduce our first speaker. He is Sebastian Lafrance. Mr. Sebastian Lafrance is a Crown Counsel Prosecutor for the Public Prosecution Service of Canada. Prior to this current position, Mr. Lafrance has experienced a part-time professor of law at the University of Ottawa and has taken part in the law branch of the Supreme Court of Canada. Mr. Lafrance has published book chapters and articles in many countries covering a wide range of law, and one of which was awarded a National First Prize. Mr. Lafrance won the first international position at the Charles Roche Public International Law Moot Court competition with his teammates and has lectured on various legal topics around the world in 19 countries so far. Mr. Lafrance holds a degree in LLB from the University of Quebec at Montreal. He studied international law at the Hague Academy of International Law, Netherlands. He also holds a degree in political science from the University of Montreal. Now, Mr. Lafrance is completing his master thesis for a Master in Law, Laval University. Mr. Lafrance studied Russian and Slavic studies at McGill University. He also studies Chinese, Mandarin, and Vietnamese at the University of Toronto. But more importantly, he studied Indonesia intensively at the Consulate of Indonesia in Toronto, Canada. Mr. Sebastian Lafrance is a hyper polyglot who speaks 18 languages fluently. I can't wait to listen to what our speaker has to present. Hence, without any further ado, please welcome our first speaker, Mr. Sebastian Lafrance. Good morning from Bali, Mr. Sebastian. How are you doing today?
Baik-baik, terima kasih banyak. Apa kabar?
Thank you. Saya baik-baik saja. Thank you for joining with us today, even though I know it's evening in the Canada, but you're willing to share your knowledge and insight about international law of data theft.
Yes.
We appreciate you so much for that.
No, it's a pleasure, honestly. It's 10:30 in the evening right now, but I'm really happy to be with you tonight, sincerely. Selamat malam teman-teman, saya senang bertemu Anda. Merupakan suatu kehormatan untuk bersama Anda semua hari ini. saya ingin mengucapkan terima kasih Profesor Pak Budi dan Fakultas Hukum Universitas Udayana. Saya harap Anda akan menikmati presentasi hari ini. Saya akan berbicara dengan Anda tentang mencuri data dan hukum internasional. Terima kasih banyak.
Mr. Sebastian, I can tell that you are really a hyper polyglot who speak 18 language fluently, even in Indonesia.
Amazing.
Amazing, Mr. Sebastian.
Terima kasih banyak. Saya cinta dan saya akan suka Indonesia. So for real, I went a few times in Indonesia. I will go again. I have a special place in my heart for Indonesia. So that's why I wanted to say a few words in Indonesian. So thank you very much. Terima kasih banyak.
All right. Mr. Lafrance, according to the time allocation from the committee, you have 30 minutes to present your presentation. So from now and 30 minutes ahead, the screen is yours.
Thank you so much. Terima kasih banyak. So we will start with the first slide here. Usually I don't comment on mohon maaf, saya akan berbicara di dalam bahasa Inggris hari ini. So I basically deconstruct the title. So this is how I would like to introduce this topic. So on the first slide, really the title, and you will see today, and you will be left with questions, you will be left with clarity, but also some things that remain to discover. And this is why today's presentation, in my opinion, is very interesting, not only mine, but also my colleagues' presentations today. So I strongly invite you to pay attention until the very end of the two sessions today. So I will discuss about the data theft aspect. I will present to you and discuss briefly about the Budapest Convention. And there's in the title, there's also its potential civilian cost. So there is the individual, the person aspect in international law. So we will discuss that as well. So that's a second brick in the wall, if I may speak it from that perspective. And also, so basically we'll discuss about the Budapest Convention, also about the Talon Manual on cyber, about 2.0, about cyberspace operations. We will discuss about state responsibility and also how individuals are becoming part of it. Sometimes it's complicated. This part is complicated. And so let's move on. Let's start. So let's basically, data theft is something very simple and complicated at the same time. As it is written in the screen here, the most common example that is given for data theft, it was mentioned earlier, is identity theft. So people stealing information from someone's computer. So what is important in data theft is it is a theft, but of data. So it has to be in a computer and it has to be information. It's not necessarily identity. It can be bank account. It can be viruses that are not viruses, that's something else, but information, private information that is stolen. So cybercrime, it's and you have the definitions on the screen, so that's why I keep it simple. But cyber crimes are crimes that are committed over computer systems by network in any means and shape or form. So what is interesting is in 2020, the last year, so there are 106 states in the world that basically implemented legislation in order to fight cyber crimes, similar to the provisions of the Budapest Convention. So let's talk about the Budapest Convention. What is it? So what is important to know, every time the topic of cybercrime is raised, it should be also discussed and talked about the Budapest Convention, because this is the only one international convention that addresses directly the binding agreement which speaks to cyber crimes. That's the only one. And this has been the Budapest Convention. Why? Because it's from the city of Budapest. Sorry, I'm not Hungarian, it's Budapest, so Budapest in English. So that's the capital city of Hungary. countries met there in 2001, agreed and ratified, and then the convention was signed and it was ratified by several countries. So this is a very important convention. And nowadays, even though I must say two big countries, namely China and the United States, had serious hesitations about this convention. They criticized somehow that it was outdated, it was not up to date. But again, we will see that it is also widely used nowadays. So there are many countries that use it. And before I move on, I always have to do a little disclaimer. So let me just take 2 seconds here. I just have to say that everything I say tonight, everything I tell you, it's not on behalf of my job of the Public Prosecution Service of Canada, but only on my behalf. So anything that I say is not binding on my workplace and the government of Canada, but only on me. In fact, it's fine because I only talk about good things and there's absolutely no problem, but I had to say this. So let's go back to the topic here. So the reach of the Budapest Convention to show how it is important nowadays in the world. So, and I want to bring your attention to something here that is very key. There are 65 parties so far, maybe there's more nowadays. Like countries like the Maldives, like very small country and the east part of Madagascar, to bigger countries like European countries, et cetera, but you don't need to have ratified the Budapest Convention necessarily to implement the principles that are presented, listed in the convention. So for example, I don't think, and I may be wrong, correct me if I'm wrong, but I don't think Indonesia is ratified the convention. However, Indonesia implemented legislation based on the Budapest Convention. So that was the idea. The idea is to basically help countries to collaborate between each other. So this is why this convention is so important, so key, because for example, you have provisions that speak to the collaboration of states. Article 25, for example, of the Budapest Convention, there's the notion of mutual legal agreement, or MLA. So mutual legal agreement, these are things that these are agreements that have countries to collaborate between them in order to fight and combat crimes, cyber crimes here, namely. So there's also a part of the Budapest Convention, we will not talk about it tonight, that speaks directly to cybercrime related to sexual crimes committed on children. So there's this that is covered, but mainly the main goals of the Cybercrime Convention, not saying it's so important, obviously it is, but what I would like to give you tonight is an overview, a brief overview of this convention. So there are many countries, and you see the map here, that ratified it, but even though some countries did not ratify it, they still implemented the principles of the Budapest Conventions in their legislation. Ratification, what does it mean? So briefly, of course, Ms. Bella knows, she did the Jessup, so she knows it on the tips of her fingers. And I know Pagbudi knows, of course. But ratifications means basically that a country will make it mandatory for itself to abide by, to comply by a convention. So that's different from a country that signs or accedes to a convention. So ratification is really the last step. So when you see on this map, parties 65, this means that 65 countries completely commit to the Budapest Convention principles and accepted to comply with the Budapest Convention. So more specifically, when it comes to identity theft or cybercrimes or data theft. So what is it is the Budapest Convention speaks not necessarily directly to it. However, the convention, in my opinion, would more than likely apply. So for example, and that's in bold on the screen, so obtaining identity information. So when a country or an individual, and we'll talk about the individual thing that bothers me, that bothered me all the time while I presented, because that's so important, and we will spend more time on this. But the fact that identity information or information is obtained from one party, a state, from a state to another state, but via computers, would be covered by the Budapest Convention. But again, the Budapest Convention applies to countries, not to individuals. Okay, so that's something that I would like you to keep in mind, and we'll get back to it later on, because the title of the presentation is the cost for individuals and how individuals are involved in this. And we will see, we'll talk about it later on, but we will see that there is a really important distinction between states and individuals when it comes to public international law. So cyberspace, and now moving on to more international law issues and cyberspace in general, and this is why this slide is interesting. You have to know that it was controversial whether international law applied or not to cyberspace. Now it is settled, but it's not very old. Like this debate was decided and was basically finished, and then people agreed that international applies, because there were issues, and we'll see, and this is why this will lead us to interesting issues that will bring you to think about this controversy. So because there's the cyberspace, it's out there, right? So we will see that there is a way to make it connected to our world, but that was part of the debate. Is it a Wild West, like it is showing on the screen, that basically is not attached to a country? And if it's not attached to a country, it's not international law, right? Because it cannot be attributed to a state. So if it's in the space, and the space has no territory, then it becomes an issue whether it is international law or not. So just wanted as basically as an appetizer for your brain here. And why so? Because the issue of sovereignty is key in international law. This is a basic thing. Some of you may already know. I know Bella knows for sure. Ms. Bella certainly knows. Bagbudi more than likely. But these are things you have to know in order to understand this, not only this controversy about why and how the international law applies to cyberspace, but sovereignty is key, and we'll see why. We'll just I will go through this quotes from the Island of Palmas case, a famous case, a classical case of the Permanent Court of Arbitration in 1928 that is still used and applied nowadays, for example, by the International Court of Justice and other courts as well. So this, what is showing here on the screen, is basically independence from a state is basically the right to exercise in a portion of the globe, to the exclusion of any other state, the functions of the state. But when you apply it on cyberspace, how can you apply this? How can you say that a computer, not the computer itself, not the physical thing that all of us are in front of today, but the internet, for example, how can you say that the internet that you are typing in, or I am typing in, is in Canada or Indonesia or elsewhere? So, and for a state. So keep that in mind, but the functions of the state, there's an answer to it. I will give it to you, but keep this first thing in mind. So the second one is the fact that the state may not exercise its power in any form in the territory of another state. So this is from the Lotus case, another famous case, classic in international law from 1927. So basically, that's a very complex, factually complex case. However, one part of the case is that there was one ship that basically did some minesweeping along the coast of Albania in the territorial sea of Albania. And then it was all a question of, was the sovereignty violated or not? So it brings us about the protection of the borders, How do you apply it? So if a state may, and it's all about the question, not the issue, but a question of the exercise of power in any form in the territory of another state. So let's say state A, let's say I'm Canadian, I'm in Canada, I use my computer and I hack. I would never do that because I don't know how, but I would hack a computer in Russia, and I do represent Canada when I do that. That's very important here, okay? Keep that in mind. I do represent the state of Canada as Sébastien Lafrance. I use my computer, then I hack a computer in Russia. Then there in any form. So basically, there could be a breach of the sovereignty of Russia because there is a Canadian that did it on behalf of Canada. So on behalf of Canada, that's will bring us to the issue of individuals. So I did speak about this. So basically, the violation of the Albanian sovereignty was violated by the United Kingdom ship, so by the minesweeping. So we can move on. So what is important here, and we move on to the core of this presentation, the most interesting, in my opinion, part of this presentation is cyber, like international law when it comes to cyberspace. And it's really important to be able to attribute acts of individuals to a state. Because if I am Sébastien Lafrance as a citizen, not representing Canada, just as the stupid criminal who hacks a computer in Russia, there are two answers to this that we will see, but could Canada be breaching international law? Well, I will say it again, the facts are really important. I will use them later on. So I, Sébastien Lafrance, as a citizen, not representing Canada, from Canada, I am in Canada now. I hack a computer in Russia or Indonesia. Does the sovereignty of Russia is breached? Because there's activity from a country, Canada, to another country that is illegal. There's data that are stolen. Let's say I am stealing data from all of you tonight from using my computer in Indonesia. So one state to another, but I do it on my own. So can it be a breach of international law? There are two answers to this, and we'll see them later on. I just will keep talking about the something else here that is important, and then I will give you the two answers. There are two approaches possible here. But to attribute, how do you, and that's very important, that's the complexity of all this, about attribution to a state of an activity or an act in order to consider whether it could be potentially a wrongful act in terms of international law. There are two ways of identifying, of using it, and these are different ways to attribute a conduct, an act to a state. The first being the effective control. So that's from the Nicaragua case from 1984 from the International Court of Justice, or the effective overall control. So basically, the effective control is the action, for example, the hacking, about the specific wrongful act, or the other approach to attribute a conduct to a state and say this is the country that did wrong, to attribute, to give. Attribution is basically to say this is the state that did the wrongful action, that did the crime, that did the data theft. So effective control is more specific over the act itself. Or the other test, to attribute, to give the conduct or the act, to say this is the state that did it. It's the second approach is the effective overall control. So this is a different approach, not from the Nicaragua case, but this is the overall control approach. It's been the approach that is preferred in Europe for the European Court of Human Rights, for example, case law. So just to attribute the conduct is complicated. So you see there are these two approaches, but this is one thing. So now I will give you the answers, one of the answers. So there is Sébastien Lafrance, who does not represent Canada, who steals data using his computer located in Canada, steals data in Indonesia. Could Canada be responsible of a breach of international law for letting one of its citizens do it and basically commit a crime of data theft? Yes and no. So the yes answer would be that because there is a breach of the obligation of due diligence. So basically what it means in practical terms is that basically Canada cannot ignore what is going on its territory. But there is a knowledge component also that is important here. So if Canada just like the state, the police knows that there are crimes that are committed on its territory, but does nothing to fight against cybercrime, against data theft, and let's say Canada is famous around the world to steal the data from Indonesians, but the Canadian government, the Canadian police or national police does nothing about this, then there could be a breach of international law. And that would not be attributed to the state. Okay, so that would still be, and that's why I told you there are two answers to the same question. This is why it's so interesting. So here, the breach would be of diligence. Diligence is to be cautious, to take steps, reasonable steps, to take action, to fight something here, crime. So there's no need necessarily to attribute the conduct of Sébastien Lafrance, the guy who steals the data from Indonesians, to Canada itself. Just by showing that Canada doesn't care enough, doesn't fight enough, could potentially render Canada responsible internationally of the conduct that was done by Sebastian. However, if you look at the bottom of the screen here, so on behalf of the state, so if I do it and let's say I receive instructions or indications or money from the government of Canada, say, hey, Sebastian, can you do that for me? Can you steal data from Indonesians? Because that would be useful from us. That's a different story now. So there could be attribution, okay? But let's finish up with the issue of diligence, okay? We'll move on to the attribution. But to complete the first answer, here you see the very important Tallinn Manual 2.0. Why 2.0? There's another one that's not necessarily relevant here fully. The other one is about cyber warfare. It's not what we're talking about tonight. But the principle of due diligence is provided in the Tallinn Manual. Tallinn Manual is a manual that's been published by international experts, that's been published by Cambridge University very recently, a few years ago. It could, but in my opinion, that could qualify. I'm not sure. I don't think there is any submission about this in court yet, but I don't see why. It's my personal opinion, but I don't see why, for example, the International Court of Justice would not accept it to be a publication that they can consider pursuant to Section 38, paragraph 1, subparagraph D of the International Court of Justice statute that basically provides that such the most prominent authors or expertise or publications can be used as a source, a subsidiary source of international law. Okay, so this Tallinn Manual, there's a famous professors like Michael, what's his last name? I forgot his last name. I have a memory blank right now, but Michael, forgot his last name. I'm sorry, but just remember his first name here. But there are experts. So a very important document here. It's a list of rules. There are more than 60 rules, I believe, maybe a bit more than that. But the rule here of due diligence, Rule 6. So it's basically about state responsibility. How can you say that the government is responsible for an action or an omission? So here in an international responsibility, a state responsibility, you have to know that it's not only the conduct of a state that may make the state responsible, but also the omission, the fact to not do anything that can make a state responsible. So if there is no due diligence, this could potentially make Canada responsible of the action of Sébastien Lafrance, even though Sébastien Lafrance did not represent the state of Canada. So here, how do you say, and it's very practical here, and two things on this one briefly. First one, you have to know, this is really key and important with respect to the state responsibility. It's also called the RCWA, ARSIWA. So that's the International Commission's draft articles on responsibility of states for international wrongful acts. This is only a draft articles, but this has become so important, and this is key in international law regarding state responsibility. So this is a legal instrument that you have to know when you want to consider state responsibility, okay? So here, practically speaking, how can you say that I am using the computer from Canada? So basically, it's a simple answer. I know many of you may say, yeah, okay, I knew it. What's the problem? There is a problem. That's why I pointed this out, okay? Because it's so basic. That's why am I talking about this? But there's a catch. So here, the IP that identifies the precise location. So to say that Sébastien Lafrance did an action on behalf of Canada or not on behalf of Canada, how can you locate and in evidence and prove in court that Sébastien stole the data from Indonesians? You use the IP address of Sébastien's computer, so you can know where it's from. However, nowadays, there are many programs that hide, even legal programs. We're not talking about big things, but there are programs that hide your IP address. So it does require special tools, and Interpol have them. There are tools that basically overrides and can still identify the IP address, the right IP address of some computers, but there are tools that basically hide it. So it can be complicated quite fast. And why is it so important that we know where it's coming from? To attribute the conduct. So that's why I put it in bold and emphasized it in the last quote below, is if I am Canadian, let's say, and I do my wrong actions from Malaysia, and I steal informations or data from Indonesians, but my IP address is Indonesia because, let's say, I use an Malaysian computer that the government gave to me. So how do you attribute the conduct? Is it the Malaysian government who gave me instructions to a Canadian guy to do it? Can Malaysia be responsible? Can Canada be responsible? Can both Malaysia and Canada be responsible to steal information from the Indonesian population? The answer would probably be that Malaysia is responsible, because here we're talking about state responsibility. Okay, we're not talking about individual responsibility. I may have committed a crime. Of course, I never committed a crime. This is all an example, but it's, don't get me wrong, I'm a prosecutor, I fight crimes. But as an individual, if I work as Sébastien Lafrance for another country, we're still talking about state responsibility. We're talking about international law, and states are primary actors. Okay, and we'll see that as well. Something else, in order to, and that's a very key, the knowledge of the
Mr.
cyber action.
Lafrance,
Yes.
my apology to interrupt, but I need to remind you that you have 3 minutes left to present your presentation.
Ah!
My apology.
Oh, okay. Okay, I'll fin. Oh my goodness. Okay, sorry. Okay. Here, I'll be fast. So here, the state that I want to talk about individuals as well. So I'll be really fast in this one, because it's key that I move on to the topic of individuals. I want to talk to you about this, and I want the audience to know about this, because that's very important to make the distinction, if I may. I'll be quick, I promise. So the knowledge of the act is important. Let's say I talk to you about the lack of due diligence, that the state can be responsible for it, but the state has to know. The knowledge must be proven. It's not just the fact that there are acts or cyber crimes that are committed on the territory of a state, that the state will automatically become responsible of the action. Their knowledge key, the knowledge element is key to attribute the conduct to the state, or if it's a breach of due diligence, that the state may still be found responsible of the acts that are committed. So I'll move on briefly to individuals. You have to know, and this is key, and I'll take 1 minute for this. You will allow me to move through the slides. So international law, as I said earlier, the primary actors of international law is states. So it's not individuals. So this presentation today, it's about how it costs individuals, et cetera, but individuals in international law, that's controversial. What is the place? What is the role of individuals in international law? Yes, individuals can be actors of international law, but for example, in human rights courts, there are several exceptions. In international criminal courts, individuals are prosecuted when they were acting on behalf of their states. However, the state is always a key player, an important part of what the role of the individuals is. So basically, an example here, the International Court of Justice Statute at Article 34.1, only states may be parties before the court. So me, or the moderator, or Pak Budi, or Ms. Bella, we cannot go to the International Court of Justice and say, my information, my data were stolen. I would like to have a case against China, against Malaysia, against Canada, et cetera. So you have to important, there's a screen, a layer between the state and the individual itself. So I will finish on this. I would have liked to talk about this monism and dualism thing, but I understand that my time is probably up, so I will finish here. Thank you very much for inviting me to talk about these issues. Terima kasih banyak semua, and thank you very much, and I hope to see you in person as soon as this pandemic is gone. So terima kasih banyak. Thank you very much.
Mr. Lafrance, thank you so much for the amazing presentation. It's such a great pleasure for me to know all of this directly from the expert. Thank you so much once again.
Sama-sama.
Yeah, terima kasih banyak. And now we're moving on to the next session. Allow me to introduce our second speaker. For the committee concerned, please show the presentation. All right, it's clear. Our second speaker is Imade Budi Arsika. Imade Budi Arsika is a lecturer at the Faculty of Law, Udayana University, Bali. He studied law at the Faculty of Faculty of Law Brawijaya University, Indonesia for Bachelor of Law degree, and the Faculty of Law Maastricht University, the Netherlands, majoring in Globalization and Law Master Program. Mr. Budi Arsika is interested in conducting research on public international law, human rights, and legal aspect of tourism. Currently, Mr. Budi Arsika serves as a managing editor of Udayana Journal of Law and Culture. It's my great pleasure to introduce our second speaker in this seminar. Please welcome Mr. Budi Arsika. Good morning, Mr. Budi.
Yes, thank
What
you
have
very
you
much.
been up to lately?
Yeah. How are you, the moderator?
I'm doing great. How about you, Mr.
I'm fine
Arsika?
also. Thank you very much for moderating this webinar very well. Yeah.
It's such a great honor for me to moderate this online seminar, actually. Mr. Budi, 20 minutes is allocated for your presentation. So,
okay, may I know,
yes.
is my presentations can be accessed already?
It hasn't been presented.
Okay, I tried to share screen now. Moment, please. Okay, how about now?
Yeah, it's
Bye.
It's in. Yeah, it's clear.
It's already.
Yeah, it's already presented.
Okay. Yeah.
Yes.
First Okay, first of all, thank you very much for the Dean that's today is represented by the Vice Dean for Academic Affairs for officially open this international webinar. And also, of course, first of all, allow me to express my sincere gratitude to the organizer, that is the Student Committee for International Law, for organizing this beautiful webinar. Also to the speaker who share knowledge and experience in this academic event. Okay, I should mention Mr. Sebastian Lafrance. Sorry, I cannot speak French and pronounce it properly. You have delivered a very excellent presentations about the international law. I learned a lot from you today. Thank you very much. And yep, how is now in Canada? I guess you work today in the very late evening, so we do appreciate. Thank you very much. Yeah. Also, sama-sama. Thank you. Who is now in Jakarta, and also Ms. Bella, the president of SCIL, who will also join us deliver presentations in this webinar. They will, both the form of them, I think they will talk a lot about the situation of Indonesia. So in my side, I will only present some aspect of international law perspective. And please allow me to confess that actually I'm not the expert in both international informational technology issues and cybercrime as well. So my presentation will deliver more or less the observations of the phenomena of the misuse of data from an international law perspective, especially in the context of the state jurisdiction and court competence. Okay, allow me to continue. Yeah, digitizing data, digitizing and digitalizations. Everybody knows that it was in the 70s when the emerge of the computer and communication technologies, along with their ability to, let's say, to process remotely large volumes of data, demands new type regulatory approach. Well, it is also obvious that we all experience today that the current civilizations rely very much on data and informations that are available to be accessed efficiently. Digitization itself represents the conversions of data or information. In the common terms is the automations, while digitalizations on other sides are related to the process of transformations of data or informations by means of digital technology. With regard to the level and ethical use of data, we can found many informations about ICT related incidents, unfortunately, yeah, including the state-supported acts of economics and industrial espionage, important data breach targeting key government agencies and even services, and also to the multinational companies. Normally, the news will report the breach of data that can be considered or classified as crimes that targeting financial institutions and individual users. The trans-border nature of internet had raised cybersecurity matters related at least to investigation. So Sebastian Lafrance is the prosecutors. So the cybersecurity problems were related with the issue of investigations, jurisdiction, and prosecution of those who committed security and data breaches. Therefore, protecting data and privacy rights online is a significant and increasingly urgent challenge for policy makers. Okay, please allow me to a little bit focus on the issue of protecting the right to privacy, because this is one of the core of the issue of our seminar today. It might be worth to look back the idea of the right to privacy as introduced by Warren and Brandeis. They published publications in Harvard Law Review for more than 130 years ago. So it was a long time ago. The article scrutinized many court decisions as well as written laws of the US and foreign law. For example, they cite the French law as well. In this article, the authors argues that the right to privacy does not prohibit any publications of matter which is public or general interest. The article also discussed the issue of the protections of the privacy of private life, as well as the invasion of the privacy that needs to be protected. Allow me to address also the issue of ethics in collecting and using data. This is the problem of the current generations, of course, everybody knows. One hand, ethics reflects a moral philosophy. Ethics concerns with what is good or not good for both individual as well as to the society, that affect how people make decisions and should behave properly. On the other hand, law itself concerns about rules or norms, legal system, and punishment for any violations. Allow me to cite the works of Marie and Bailey from Institute of Ethics. She noticed that there is a consensus on the existence of a rights to informational privacy, but not on the extent to which policies should go to protect the right or on how to implement such policies in practice. Also in her works, in a pluralistic society, translating a moral right to privacy into enforceable policy is a political problem. Okay, we also note there are, okay, sorry, I guess, yeah, sorry. There are several principles established from practice. We have here my colleague, Professor Supasti, also Ibu Suksma, international trade law, yeah, they know about lex mercatoria, yeah, the law that based on the practice by the trader. That there are many principles established from practice at everywhere. We cannot say this is national or international because everything is online, yeah, transboundary. One I would like to note of guidance notes on data privacy, ethics, and protections for the United Nations Development Group that was designed to establish common principles around the UNDG to support the operational use of big data for the achievement of the Sustainable Development Goals, or SDG. Yeah, of course, it is not a legal binding document, but at least it provides a minimum basis for self-regulations to be further elaborated and regulated. Well, it is also recommended by this guidance note that designated legal, ethics, privacy, and security experts be consulted regarding the implementations of not only the implementation but also the compliance of this guidance notes. Just allow me to continue, not very much talking about the national law, regulation, and policy, because Ms. Alia and also Ms. Bella will do that, but at least we can see some international instrument. Thank you very much for Mr. Sebastian Lafrance. Yeah, you have introduced the Budapest Convention very well. Yeah, yeah. So there are several related conventions, including that you mentioned the major one. And we can find, for example, the concerns of the international society through the United Nations General Assembly resolution. What I can trace so far, for example, the resolutions 98, 167, it was in 2013, that calls upon states to respect and protect the right to privacy, including in the context of digital communication. So as far as I'm concerned, since 2013 until 2 years ago, there were at least four resolutions adopted by the General Assembly, yeah, discussing the issue of the right to privacy in the digital age. 1 year after that resolutions, yeah, the General Assembly again calls upon states to provide individuals whose right to privacy has been violated by unlawful or arbitrary surveillance with access to an effective remedy. They put also the needs to use and to obey the international human rights obligations. In 2008, Yeah, the General Assembly not only calls upon states, but also calls upon business enterprise. Yeah, again, my previous colleagues that I mentioned, Professor Supasti and Dr. Suksma, they work a lot with regards to the business and human rights ethics. Yeah, so the business enterprise in this 2018 General Assembly resolutions, yeah, were called, among others, to meet the responsibility to respect human rights in accordance with the guiding principles on business and human rights, and also the framework including the right to privacy in digital age. It is very interesting. 2 years ago, in 2020, there are more and more calls upon the business enterprise. So according to the resolution in 2020, the business enterprise are encouraged that, so I mean the enterprise that collect, store, use, share, and process data, yeah, they are encouraged to put in place adequate safeguard that seek to prevent or mitigate adverse human rights impact that are directly linked to their operation, product, service, including where necessary through contractual clause or notification of any relevant entities, or abuses or violation when misuse of their products and service is detected. So this is related to the private international law issues. Allow me also to mention one declaration of the G7. Sebastian, Canada is part of the G7, I do believe, yeah, beside France, Germany, Italy, Japan, and the UK, and also the United States. Indonesia, of course, not part of the G7. There was a 2017 declarations on responsible states behavior in cyberspace. In the declaration, it says that no country should conduct or support ICT-enabled theft. So this is about the theft, yeah, data theft. I repeat, no country should conduct or support ICT-enabled theft of intellectual property, including trade secrets, yeah, or other confidential business information, with the intent, okay, this is the mens rea, with the intent of providing competitive advantage to companies or commercial sectors. Now, I guess we have only 5 minutes. Yeah, allow me to talk about the state's jurisdiction. Yeah, jurisdiction refers to a state's power and authority to enforce law and punish non-compliance with law. It is linked with the state sovereignty, as Sebastian Lebrans mentioned previously, which is a country right to exercise authority over its own territory. Well, the first category of state jurisdiction is the territorial jurisdiction based on the principle of territoriality. It will regard to the locus commissi delicti. However, given that there are no geographic boundaries in cyberspace, yeah, it is quite difficult to determine these jurisdictions in the context of cybercrime. Yeah, for these reasons, yeah, states rely on several types of factors to determine jurisdiction. For example, principle of nationality, with regards to nationality of the perpetrators. The second one may be principle of nationality or the passive principle about the victim. Also the protective principle. This is also has been discussed by the expert. Okay, what's about the extraterritorial principle? This is so the states can exercise jurisdictions outside of their own boundary. We can see, for example, the United States America Children's Online Privacy Protection Act, or COPPA, and certain provisions in the European Union General Data Protection Regulations that were created to protect the privacy kids online. Both laws have an extraterritorial scope, which means they are enforceable against companies based anywhere in the world that have users in USA or EU respectively. Example, for example, the USA COPPA, yeah, extend to foreign service providers that direct their activities to US children or only collect information from US children. While the EU GDPR, the European Union General Data Protection Regulation, has also extraterritorial reach, meaning that many organizations based outside of the European Economic Area and the UK, yeah, must comply with GDPR obligations for personal data. Okay, moment please. This is the case, yeah. Okay, allow me to mention two case law. The first case law is the case law in the Wales and Great Britain. So due to Brexit situation, the UK, UK, United Kingdom of Great Britain and Northern Ireland applies the GDPR through Data Protection Act 2018 that adopt a similar key principles, right and obligation. However, still, there are implications for the rules of transfers of personal data between the UK and the EEA. This is very interesting. This is the first judgment in England and Wales which consider the extraterritorial reach of general data protection that settle a case involving operator overseas websites, which actually has no physical presence in the UK or targeting of UK customers. Yeah, this article, the justice in this court assessed the applicability of the Article 3 of GDPR to a US website, and the judge in the judgment, the justice clarifies that Article 3 of the GDPR might apply to some processing activities of the non-European business, but not other activities. With regard to the second case, this is quite fresh from the F1 actually, just a few months ago. Everybody was a little bit shocked when hearing about the issue of Facebook, because many people over the world, maybe I don't know the current numbers now, at least in Indonesia, there are many users of Facebook. It is a leading case on national jurisdiction in data protection that attracted the attention of international community. After Facebook changed its privacy policy in 2014, the Belgian Privacy Commission initiated an investigation and including some good university. Yeah. And the study from those universities revealed that there are several Facebook practices that potentially violates the Belgian data protection law. Yeah. The case was then submitted before the Court of First Instance in Brussels. Simply, after 2 years, the Brussels Court of First Instance held that it has jurisdiction to give a ruling insofar as the action concerns Facebook Ireland, Facebook Inc., and Facebook Belgium.
My apology, Mr. Arsika. I need to remind you that you have 3 minutes left to present your presentation.
Thank you very much. Yeah. In the Court of First Instance, the decisions was made unpleasant feeling for the Facebook. Of course, the Facebook disappointed with the decision of the Court of First Instance. Therefore, the Facebook bring the case to the Court of Appeals in 2018. But the DPA, the Belgium Data Protection Agency, act as the legal successor of the President of Privacy Commission and the Privacy Commission itself. The DPA believes that Facebook infringed Belgian and European legislations by collecting information on the browsing behavior of internet users, whether or not they are members of the social network, by placing cookies, and collects information on the surfing behavior of millions internet users. The Court of Appeal actually unsure whether or not they have a full-fledged jurisdiction to hear appeal in relation to Facebook Ireland and Facebook Inc. But they believe that they have jurisdictions to give a ruling to the case with regards to the appeal by the Facebook Belgium. Therefore, the Court of Appeal of Brussels bring the case and refer the case to the European Court of Justice. The Court of Justice of the European Union for preliminary ruling. Well, in this Court of Justice European Union, it was actually 2 months ago. The judgment was released by the Court of Justice of European Union. Yeah, it is very interesting that European Union, this court answered all the 6 questions given by the Court of Appeal. But what I would like to inform to the all audience is that the court read together the GDPR. The court read the GDPR together with the Charter of Fundamental Rights of the European Union, especially Article 7, 8, and 47, with regard to issue respect for private and family life, protections of personal data, as well as the right to an effective remedy and to a fair trial. The court also assessed that activities of the establishment on the Facebook group located in Belgium must be considered to be inextricable link to the processing of personal data at issue in the main proceeding. With respect to which Facebook Ireland is the controller within the European Union. Accordingly, both processing must be regarding as being carried out in the context of activities of an establishment of control within the meaning of Article 3, Paragraph 1 of the 2016 regulation. Moderator, thank you very much for allowing me, to remind me about the time. This is the concluding remarks, less than 1 minute, I do believe. This issue, data theft, for example, or the misuse of data, it is the interdisciplinary matter. Legal scholar cannot deal only. So I do believe in the court, they have several friends of the court in dealing with this case. Yeah. And number 2, there is the concerns of international community. Even Sebastian, Indonesia is not state party of the Budapest Convention as far as I'm concerned. Yeah, there are many international organizations and network that becoming, let's say, observer. Yeah, for example, the African Union Commission's Commonwealth Secretariat, yeah, Interpol, International Telecommunication Union, and also United Nations Office on Drugs and Crimes. And lastly, I'd like to underline that the court competency is very important, because as we can see on the previous case I mentioned, even the Court of Appeal in Brussels unsure with their jurisdiction, and they revert the case to the European Court of, European Court of Justice. Yeah, this is not easy for the court to establish the competence of jurisdiction, because even we know that the state's jurisdiction are also in discussion. I guess that's all. Thank you very much for your attention.
Thank you so much, Mr. Asika, for the amazing presentation. Mr. Asika presentation is the last presentation in the first part of our sharing session. Now we will proceed to the discussion session, where I will be delivering some of the questions that have been submitted to the link provided by the committee earlier. For the participants who have still questions, who still wants to ask questions for our participants, you can submit the question through the link that's provided by the committee on the Zoom chat box below. All right, I will be delivering some of the questions that have been submitted to our speaker. The first one is coming from, wait a moment, I will read the question. The first question is from Sultan, Udayana University, and addressed to Mr. Sebastian Lafrance. The question is the criminal justice process of data theft is the same as the conventional criminal justice process? For Mr. Lafrance, it's your time to respond to the question.
Yeah, the answer will be short, because it is the same. There is no criminal law. It's a matter of domestic and national legislation. In Indonesia, it's the KUHP. In Canada, it's the criminal code. So every nation has its own criminal code. What is more interesting to look at is whether a country addressed directly or not the issue of data theft in its own legislation, or cover it with its provisions or its articles about theft or fraud or like sections like that, right? So it's always, is it the same thing? Yes. That being said, one last thing, if I may, Interpol, Singapore and Asia, for example, and I lectured there before, but Interpol in Singapore helps Asian countries and African countries now, I think, to collaborate between each other when it comes to such crimes. So there, even though it is a matter of national jurisdiction, there is still international cooperation, whether the countries are part or not part of the Budapest Convention. So there is a lot of work done by Interpol about that, because data theft, as long as it can be inside a country, like Pak Budi can decide tonight. Of course, Pak Budi is super honest. He will never do that. But let's say Pak Budi is a hacker and he hacks the neighbor, or he hacks you, Mr. Moderator. So that's in Indonesia. It's not a matter of international law. That would be a matter of national jurisdiction. But usually data, not usually, it's not true, but oftentimes data theft takes an international level. So of course, different jurisdictions come into play, but still, criminal law is always a matter of national jurisdiction. So there is no, just to finish on this, the International Criminal Court, for example, they would not have cases with respect to data theft, because that's not part of their crimes, right? So they cover genocides, murders, mass murders, so that that type of crimes will not be heard by the International Criminal Court. So there is no, and the International Court of Justice, would they hear cases like this? Maybe, maybe not, but it's all of which to say, first and foremost, this is all a matter of national jurisdiction. So yes, that would be the same thing.
Thank you for the response, Mr. LaFrance. I will read the two other questions for you. You can answer it in turn. So the second question is coming from Dian Kurniati. She asks, what are the form of cybercrime set out in Budapest Convention, and how the procedure of cooperation between the countries concerned in the same case? From Mr. LaFrance, it's your time to respond to the question.
Yeah, thank you. I don't know if I can share my screen. I would love to, because that will help. I can, I think, yes. To answer the first question. Okay, fantastic. Thank you so much. So in terms of the types of crimes, I'm not going to spend a lot of time on this, because that can be complicated quite fast. But the types of crimes that are the substantial offenses that are covered by the Budapest Convention, it's the first one, the illegal access. That's the most interesting one for, well, the most interesting one, not necessarily, but the most relevant when it comes to data theft, right? So it's one person or state, actually that's state here, that has access to computers from another state. So that would be an illegal access. So that's the more sensical article that would apply here. But in terms of other substantive criminal law offenses, there would be illegal interception that applies Article 3. You can see it on the screen here. So data interference, etc., misuse of device. So I'm not going to talk in detail about this, but more interestingly, the Article 2 is the most relevant in my opinion regarding data theft. Okay, so keep that in mind. With respect to the other question of the collaboration between countries, I would like to go to, of course, I'm going to read it for you, but I would like to bring you to Article 23 and Article 25, which are the most relevant articles of I hope you're not busy, because I'm browsing the document right now. Stay tuned and stay with me. So here, regarding international cooperation, Article 23, and we'll move on to Article 25. But there's a word I would like to bring your attention to. So you see my screen right now, hopefully. I emphasize and put in bold the word shall. That's very strong. And in English, well, when you say you shall do it, it's not you must. It's more than must. It's an obligation. So if a state ratified the Budapest Convention, that means that it has to collaborate or cooperate with the other countries in order to share information, to help, to assist. So it's a very strong word. To shall, it's very strong. Again, but like Pak Budi said, what about a state? Pak Budi mentioned that Indonesia has not ratified the Budapest Convention. So why would Indonesia care about it? Can Indonesia use it? The answer is yes. And why do I say so? In international law, it's not black or white, as you, Ms. Bella knows particularly because she did the Jessup, and in the Jessup we have two parties who deal brilliantly, really wisely with difficult issues, and everybody has good arguments against each other. It's not black or white. Okay, it's not easy to. So why Indonesia can still rely on it, can still use the Budapest Convention, or actually I believe that Indonesia implemented, or I read a few articles about this, but they inspired themselves. The legislation is inspired somehow by the Budapest Convention in order to include some offenses, right? So, and it's KUHP, for the Criminal Code of Indonesia. So the Budapest Convention, there are substantive criminal offenses, but it's also a tool. So many countries ratified it that it becomes a very heavy influence. So for a country like Indonesia that did not ratify the Budapest Convention remains and is still a legal instrument that has weight in international relation, right, with another country. So if we move on to Article 25 briefly, there's another term I would like about the collaboration, cooperation, and what about the mutual assistance between two countries? Again, so for all countries, and I know Indonesia did not ratify it, but the wording is very strong. So, and this is a combination of Article 23 and Article 25. So the wording of Article 25 says here, the parties shall, so it's stronger than must, afford or give one another mutual assistance to the widest extent possible. The widest. So let's say Malaysia and Indonesia, let's say they are friendly, but Malaysia says, well, I want to help my Indonesian neighbor because we're brother countries, but honestly, I'm jealous of Indonesians, so I'm not going to help them that much. I'm just going to help them a little bit because Indonesians are getting too good and they are fighting crimes too well. So Malaysia is not going to help that much. Well, they cannot do that. If they ratify the Budapest Convention, if they do so, not help to the widest extent possible, there could be a breach, okay, an international law breach of this agreement of Article 25, paragraph 1, okay? So, and states know it. So, but states want to collaborate anyway, right? So there is no reason unless states, but the reason could be that states are competitors, that states want to harm another state. So the use of such strong language is compelling for states to collaborate to the widest extent possible. That's strong words again. So it means full-blown collaboration. My police will help your police, and vice versa. For states, again, that did not ratify it, what's going on? Still, the weight of this convention, the only one, as I mentioned earlier, the only one in the world that is a binding convention that so many countries, 65 or more now, 65 countries at least, ratified, that several countries signed. Signature is not as strong as a ratification, but it's still a commitment somehow to that, a recognition at least of the importance of a legal instrument at the international level, that it has weight. And international law also, as we all know, it's also about international relations and international politics. If a country starts to misbehave, not collaborate, and say, I do it on my own, I don't want to help you. Well, we have extreme cases of states like this. There is one in Africa that is a rogue state, Somalia, where there are many, like there are problems of pirates and so on, that there are serious issues. That's one example. right? I don't want to target the Somalia. I know actually personally one Somalian, very nice person, very nice guy. It has nothing to do with that. But the state itself, there are several issues like this. So if state starts to not collaborate, even though they are not party to the Budapest Convention, because the Budapest Convention has so much weight that it may give the country a bad name. So even though there wouldn't be a breach in terms of international law, this could play badly in terms of international relations for the same country. That would be my answer. Short as always, as you heard me. I'm sorry I gave a too long answer. As my wife says, I speak too much. I'm sorry, but thanks.
No, Mr. Lafrance, you're amazing at answering that question. Where it's very enlightening us about that question. Now we're moving on to the question for Mr. Arsika. The question is from Yoga. He asks, since the jurisdiction of internet is still full, so what is the extent universal jurisdiction to exercise such crime? For Mr. Arsika, it's time to you respond to the question.
Thank you very much to moderator Mr. Dananjaya. Well, before I address, I respond the questions raised by Mr. Yoga, allow me to underline some beautiful words because I admit I do agree with your statement, Mr. Lafrance, that under international law, there are always gray areas, yeah, that will open the politional actions sometimes. But it can be one politional actions sometimes can be regarded as a crime of aggressions by other parties. That's for example. Yeah. So there is no black or white. So we are very, we are very happy because in the SCIL, most of them involved in the mood court. So they know that the mood problem comprised of something that it can be various perspective. Yeah, there is no, absolute answer sometimes. Well, allow me to respond to the questions about. May I read again? Since the jurisdiction of internet is still vague, so what is the extent universal jurisdiction to exercise such crime? A few minutes ago, when I mentioned about the state jurisdiction under international law, as far as I remember, I mentioned about the limitations to exercise the territoriality jurisdictions because of the matter of the locus commissi delicti. But there are also a principle of nationality, or what's called as active personality principle, in which a state have the authority to prosecute their nationals, even if these nationals are outside of their own country. What about the personal or passive personality principle? Yeah, this is a little bit lesser degree. Yeah, sometimes used. So Mr. Lafrance know better than me because you are prosecutor. Yeah. So the nationality of victim can be used to assert jurisdiction over a crime. For example, because we are in Bali, I hope I still remember. It was almost 2 decades ago with the case of Bali blast, Bali bombing. There were victims that maybe 88, if I'm not mistaken, or more than 80. The victims were Australian nationals. At the time, there was an issue whether or not the Australian government can bring the case before Australian court, because the family of the victims will feel more justice if the prosecution will be held in Australia, for example. But that was not the case. After the proper investigations by the Indonesian police at that time, the court was set in Indonesia. So that's was an example of how the passive personality principle was not exercised to the case, even involving the number of victims that's quite huge. Well, but this is not about the let's say the case of terrorism. This is about the crime, cyber crime. lastly, the protective principle is when a state can further establish jurisdictions because crime committed in other countries. For example, is the case of espionage. But this example, the espionage activities impacted the interest and security of the states that are seeking jurisdiction over the case. Now, the question of yoga is about the Universal Declaration. Allow me to clarify that any state can establish jurisdiction over certain transnational crimes, such as mass atrocities. The good example is the genocide, of course, which are few as affecting all human beings, irrespective of geographic locations, when the state where the crime was committed is unwilling or unable to prosecute the offenders or the perpetrators. I guess not only on the genocide case, I mean the international under the international law of the sea, the case of piracy also part of the universal jurisdiction. But now, is it possible? For the case. I hope some of maybe later we have here Bella, Miss Bella. A few years ago, I was read of one moot problem of one national round moot court competition. In that moot problem, it says one of party who involved in the war crimes, sends information and picture through social media that was interpreted as something not interpreted, that was then I would say how could say the initiating the war crimes. Everybody know about the hook, the improper information. If the stealing of data, let's say the hijacking of let's say the server, for example, and then the misuse of data and information is part of the establishment of a crime. Please correct me, Mr. LaFrance, please correct me, because this is maybe very sensitive. It may be part of the investigation by the Council of Prosecutions. However, this is quite difficult in the context of the proving, in the context of the how to raise the evidence, in the evidence process, because it is not easy. In the International Criminal Court, for example, those who are prosecuted, will be checked about their mens rea and let's say direct involvement based on the chain of commands, for example, and the rank of height. But if there is a if there is a crime that involves a cyber security, then it is not easy to prove that. And I'm not sure 100%. I'm not sure 100% whether or not the International Criminal Court will scrutinize very detailed the issue of cybercrime, in assessing that one. But sorry, I don't know precisely because I never checked the case law that related with that. Maybe Mr. LaFrance will check that. But at the national courts, I found some cases in which the national courts do that. The national courts do that. But under International Criminal Court, because I never read the case that indicating the court do that, I have no sufficient information about that. But I do believe I need the added information from Mr. LaFrance for this issue. Thank you very much.
If I may, I just would like to add one thing, and that Pak Budi raised that is really important is and as a prosecutor, of course, I'm confronted to that kind of things really often. I know I deal with national law, but I do know when I worked, well, I didn't work, but I presented at Interpol. I had the occasion and the great chance to meet with prosecutors from various countries, and also one prosecutor at the International Criminal Court. So basically, most of us, including at the International Criminal Court, for prosecutors, face the same type of issues regarding evidence. Because it's one thing to have the evidence, or to think to have the evidence, and this is why the Budapest Convention, and that's the only connection I will make with what Pak Budi just said, is that's why we do have the Budapest Convention, because some countries, they don't want to give the evidence. Let's say you have a country, and I want to choose my words because I don't want to be offensive for some states, not Indonesia. I love Indonesia, so there's no problem. I can say whatever I want about Indonesia. I love the country. I love Indonesians. I love the language, the culture, the food, delicious. But some countries in the Middle East, for example, that host terrorists, they don't want to give evidence. They are not necessarily rogue state or terrorist state. They're not, but they do not want to collaborate for political reasons, for strategic reasons. It's not always political, but they don't want to share the evidence, share the information that will basically, in their eyes, will make them weak or be seen as weak. So collaboration between states and to the sharing of evidence, it's not that easy. And I know it for a fact. I cannot tell you why. I wish I could, but I can't. But I personally know it is quite difficult and frustrating for prosecutors sometimes, which may not have a case, because you may know this person went to that country and to keep in let's say, stole data information, but the country doesn't want to give me the evidence, doesn't want to give my prosecution service the evidence so that my citizen who committed the crime will be prosecuted. So that's practical question, but I just wanted to add that to a very, very interesting angle that Pak Budi raised.
Yeah. Thank you very much. Thank you very much, Mr. Lafrance.
Thank you very much for the speaker for the response to the question that have been submitted by our participants. That question marked the end of our sharing session today. Now, each of our participants has the chance to give closing statement regarding the presentation that has been conducted previously. I'd like to give firstly the screen to Mr. Sebastian Lafrance to give his closing statement.
Well, my closing statement will be quite personal, I have to say. I had a great time presenting tonight. I made a lecture that was too long, and I wish I could have presented more about this topic, but you know what? I know I will go back in person to Indonesia, and I will go and meet Pak Budi and most of you guys, if you're still students, then hopefully when the pandemic is gone, and I will meet you in person, and that will be a great pleasure. As I said off the record, but I will happily say it on the record, I went to Bali, unfortunately was not to give a lecture. At the time I went to Jakarta, Yogyakarta, and Surabaya to give lectures, but Bali, I didn't have the great honor to know Pak Budi way back then, so otherwise, for certain, I would have stopped at Udayana University and give lectures and meet students and meet with great happiness Pak Budi. All of which to say, and this is not to be taken lightly, I mean it. The first time I went to Indonesia, my wife knows, she saw me. The first thing and sorry to tell this story, it's really personal, but it's to show how much I do care about Indonesia, Indonesians, and the perfectionism, the professionalism of Indonesians. So first time I went, I took the taxi with my wife, and I started immediately practicing Indonesian. I basically spoke Indonesian 70% of the time, and my wife was desperate because she's a Spanish speaker. Speaks her English was okay at the time, not bad, not very good, but So she heard me talking Indonesian. I didn't want to stop. I just fell in love with the country. So for tonight, specifically, I find everybody, I must say, I'm very impressed by all of you. So I raise my hat. Congratulations for this great event. Thank you very much for inviting me. Of course, I'm really honored. And I say, of course, because of course I am honored because I care. I never saw Indonesia as the big Canadian guy myself who's gonna show how great Canada is for Indonesia. I always saw and still see Indonesia as a great nation, a great country in the world. So it's always an honor as a Canadian, as a human being, to be in such close contact with great people like you tonight, who showed great and outstanding professionalism, all of you. So that's very impressive at such a young age. So you will go far in your career. So, and thank you to the attendees to have respectfully paid attention. And I hope that Budi and myself were able to catch your attention and teach you a few things about this great topic that we discussed tonight. So thank you very much. Terima kasih banyak semua.
Thank you so much once again, Mr. Sebastian Lafrance, for your willingness to share knowledge with us today. Now I'd like to give the screen to Mr. Arsika to address his closing statement regarding to the presentation.
Well, as a citizen of Indonesia, I'm very glad that the big Canadian guy several times mentions about the good things about Indonesia. Even you mentioned about the jealousy of Indonesians criminal law enforcement here. But just a few seconds ago, you mentioned Indonesia several times about good things, and yeah, we are very glad in this August, because August is the month of Indonesian Independence Day. Yeah, but of course, we also, as part of the international society, we observe that Canada also play a role in contributing into the international peace and security. And also we learned a lot about the issue of human rights, yeah, as well as how Canada issued a policy on multicultural society. That may be something we have to learn from Canada and you especially, Professor. Yes, please.
Oh, so I'm sorry, I don't want to cut you. I don't want to be rude. Actually, multiculturalism, that's something I could talk about. That's provided by Section 27 of the Charter of Rights. And that's, I published about this topic also. And this is something that is important to me personally, but that would be, and that's something we have in common with Indonesia. So that would be with the Pancasila and the constitutional principles. So wonderful eventually. Sorry, I don't want to cut you.
It's okay. Thank you. You mentioned about Pancasila, our state ideology. Well, thank you very much also to the upcoming presenters, especially to the moderator and the student committee for international law who organized this seminar in coordination with the deans and also the head of the information and cooperation affairs of the Faculty of Law Udayana University. Thank you very much for organizing this one. And to be honest, as I mentioned at the very beginning, I'm not the expert of the IT issue as well as the cybercrime, but thank you. To be honest, the SCIL assigns me to work a lot on how to find something that related to at least my field of research. But so I'm happy with the questions with regard to the universal jurisdiction, because I don't want to talk about a lot about the Belgian Act on the universal jurisdiction on that, but at least that highlights me. And thank you very much for the clarifications on the practical aspect, on how to find evidence that you mentioned a little bit frustrating for even the Council of Prosecutors. That's something good for us to know. So I think that's all. Thank you very much to all speakers, moderators, committee, and all participants to keep an eye and also hearing this presentation. Thank you very much.
Thank you, Mr. Arsika, for the closing statement. From the sharing session and the discussion session previously, we can conclude that data theft is perceived as cybercrime in international law plane. However, such cybercrime has sparked controversy among the scholar as how the basic principle of international law, such as sovereignty, which is considered by the territory possessment, was unclear and is almost impossible to detect the place of the conduct of such cybercrime. Now, the controversy has been resolved by the existence of several international law regime, which are Budapest Convention, Allen Manual, and it can be connected to the state responsibility principle. The crime perpetrated by an individual can be attributed to the state if it's done on behalf of the state in question. The state can be also said to breach the obligation to the due diligence. Individual can sometimes be the subject of international law, but state are the most important subject to international law and how it will exercise the authority to punish the non-compliance of the law. Data theft has been a topic of discussion in many countries, and it shows the concern of our international community. It can be seen in the UNGA and other international meeting among countries in G7. It can also be said that data theft matters is a matter of interdisciplinary matters, which is not only about legal or law. It requires other field other than law. The last thing that remains as gray area is the core competence of national court, especially as how in the case of Brussels court that that's stated that it still remain gray for its competence uh, to examine the case of about data theft. I'd like to say big thanks to our speaker for joining with us today. Thank you, Mr. Lafrance and Mr. Arsika for the new insight and knowledge. I also appreciate the enthusiasm of our participants to get involved in the seminar. Now it's time to group picture. For the participants who haven't turned their camera, please turn on your camera and show your best pose. For the respective committee, please take good pictures of us. I will count. Wait a moment. I will count. Okay. I will count 3, 2, 1. For the next slide. 3, 2, 1. For the next slide. 3, 2, 1. For the next slide. 3, 2, 1. And for the last slide. 3, 2, 1. All right. Our photo session marked the end of the first part of our sharing session. I'd like to once again thank Mr. Lafrance and Mr. Arsika for joining with us today. For the speakers, should you have other agendas, please without hesitation to leave the room. Thank you. Our next agenda is presentation by the third speaker. Before that, allow me to introduce her. She is Ms. Made Ananda Bella Cahyani. Ms. Cahyani currently serves as the president of Student Community for International Law after finishing her duty as the head of academic division in the previous year. She is also a student relation manager of Legalist Society. As a law student in Udayana University, Ms. Cahyani has experienced and achieved many amazing things. In 2019, she achieved champion, best memorial, and third best oralist award in the national round of International Humanitarian Law Moot Court competition and served as the delegates of Indonesia in the Asia Pacific round of IHL Moot Court competition 1 year later. Her moot court path continues as she joined global round of Philip C. Jessup International Law Moot Court Competition as an oralist. Ms. Chahyani was also awarded as the second most outstanding student of Faculty of Law, Udayana University in 2021. She was selected participant in Bali Democracy Student Conference, an event organized by Indonesia's Ministry of Foreign Affairs to discuss about democracy, youth, and COVID-19. Without any further ado, it's my great pleasure to introduce our third speaker, Ms. Bella Chahyani. Good afternoon, Ms. Chahyani. How are you doing today?
Good afternoon, Danan. I'm feeling so great. How about you?
I'm feeling great too. So how have been your college life has been?
Okay, it has been pretty overwhelming, but gratefully, I really enjoy my college time. Thank you.
Sure, you did achieve a lot of things in college. So yeah, I hope I can be, you can inspire many other, student in student community for international law, especially to achieve many amazing things as you did previously. Mr. My apology, Ms. Chahyani, you apparently have 10 minutes to present your presentation. So from now and 10 minutes ahead, the screen is yours.
Thank you so much, my fellow Dananjaya. Okay, so I would like to ask the operator to present my presentation. Okay, today I would like to present regarding the trends and threats in cyberspace, noting that during this pandemic, we all know that the trends in digitization as well as the trends in cyberspace are evolving. And also, we all know that more trends, of course, more threats. Okay, so cyber threats are also constantly evolving in order to take advantage of online behavior as well as online trends that are currently happening among the civilian population. Okay, so next slide, please. Okay, the current trends in cyberspace, which I took the data from Economy C. We all know that the 5 leading internet economy are firstly e-commerce, that we all know it includes marketplaces, it includes malls, direct to consumer, which usually refers to selling products directly to the consumer in evolving by passing any third party in retail. And the transport and food, we all know that it is very common for us in which we can like order any food and order any transport just by tapping our phone, and yep, the food is coming. And in Indonesia, it is all known like Gojek and then Grab, if we all know. Okay, and then the next one is online travel. Okay, online travel in which we can book any flight, any hotels, and we can go around the world just by tapping our phone. And then, yes, we can choose any destination that we will want to go. And then in online media, if we open any application, we will see an advertisement. And then gaming is also increasing during this pandemic to kill the boredness of the people. And then video on demand like YouTube, music on demand like Spotify and Apple Music are also increasing. And then financial services, which take, pardon me, which play a big role during this pandemic, noting that the use of cash and the use of card in the payment may increase the spread of the virus. So it is very essential for financial services to be used because it can prevent the spread of the virus. And then other than those 5 leading trends, we also have health technology that provides devices, medicines, vaccines, procedures, and systems developed to solve health problems and also to increase the quality of life, especially our health. And then we also have educational technology that is used to facilitate learning, especially during this pandemic where we cannot meet face to face and the learning process must be held virtually. Okay, next slide. I will not talk more about the trends because I believe that most of us are already common with the trends that are currently evolving during this pandemic, because I believe that most of us are coming from millennials. Okay, so I will be moving on to the global cyber threats in relation to the COVID-19 pandemic, in which I took the data from Interpol. No. Okay, so the following cyber threats are the main cyber threats that are evolving during this pandemic. So the first one is online scams and phishing, with the percentage of 59% among the world, in which cyber criminals are creating fake websites related to COVID-19 to entice victims into opening malicious attachments or clicking phishing links, resulting in identity impersonation or illegal access to personal accounts. Okay, so I forgot to convey this before, but I would like to convey a disclaimer that I'm just a law student. I'm still learning, so I apologize for any mistaken belief that I said or mistaken words that I convey during this seminar. Okay, and then the next cyber threats that also happening is malware with the percentage of 36%. Malware consists of programming designed to disrupt or deny operation, gather information that leads to loss of privacy or exploitation, and to gain unauthorized access to system resources and other abusive behavior. Phishing, scam, fraud, malware, or ransomware, all of these cyber threats may amount to any data theft that also resulted in civilian costs. Okay, so the next cyber threats would be malicious domains with a percentage of 22%. Malicious domains are one of the critical manifestations of cybersecurity attacks that severely posing threats to people's privacy and property by providing malicious services. For the fake news, we all know that an increasing amount of misinformation and fake news is spreading rapidly among the public, especially during this pandemic. It includes uncertain social and economic situation in the world. It includes unverified information, inadequate understood threats, as well as conspiracy theories, especially regarding the COVID-19 pandemic. Okay, so next slide, please. Okay, moving on to the cyber threats that are currently happening in Indonesia. So previously, I was talking about the global cyber threats, and then I am moving on to the cyber threats in Indonesia, in which National Cyber and Crypto Agency, or we all known as BSSN, noted that there were around 741 million cyber attacks that occurred only from January to July 2021. It is a very large number, noting that it is also increased from the previous year. Okay, so basically the cyber attacks mostly will target governmental sector, and then financial sector, and then telecommunication sector, law enforcement, and other sectors as well. Moving on. Moving on to the next slide, please. Okay, noting that cyber attacks increased in Indonesia, and I also have mentioned that cyber threats may amount to any data theft that also resulted in civilian costs, I would like to highlight regarding recent data breach that were happened in Indonesia in 2020 as well as 2021. The first one I would like to highlight regarding Tokopedia data breach, which happened in March 2020, in which Indonesian tech giant, Indonesian tech giant Tokopedia has fallen victim to a massive data leak in which 91 million of its user data were stolen, sold for $5,000 and shared in a Facebook group. So basically, these data were sold in a dark web named Reddit forums, and most of the data breach and most of the data that were stolen by the hackers were also sold in this dark web.
Miss Jayani, my
Yes.
apology to interrupt, but you have 2 minutes left to present your presentation.
Okay,
Thank you.
that's a quick time. Okay, but I will make it simple. Okay, so I will now moving on to the Indonesia's Healthcare and Social Security Agency, which is also known with BPJS, and then the Population and Civil Registry Office, and then BRI Life. So there's a lot of data breach in Indonesia that amounted to millions of data stolen by the hacker. And then next, please. Okay. I believe that this data breach were occurred because of the existing law that govern personal data protection in Indonesia are not strong yet. However, I would like to highlight regarding the government regulation number 71 that was adopted on 2019, as well as law number 11 that was adopted on 2008, which also amended to law number 19 in 2016, in which these regulations not necessarily governing regarding personal data protection. It is generally governing regarding electronic transactions, but in that regulation, it is there are some articles that govern regarding personal data protection, which can be seen in Article 1, Article 14.1, 14.5 of the government regulation number 71 that was adopted on 2019. And in law number 19 that was adopted on 2016, it was governed in Article 30 until Article 32, and then Article 46 until Article 48 regarding the punishment for parties that steal or disseminate the personal data or other individuals without their consent. So basically, the data breach that I mentioned earlier may be charged with these articles. However, the government never took this crime seriously. So we really need the urgency. So we really in an urgency to adopt the law that is governing regarding personal data protection, which I believe that it will be delivered by Ms. Alia as the next speaker. Okay, so next slide, please, if I still have time. Okay, do I still have time? Because if not,
your
okay.
time is actually up, Miss Jayani.
Okay,
My
that's
apology.
okay. So I believe that all of the data breach that I have mentioned and I have delivered earlier have the impacts as well that we all know, like it can amount to identity theft and then financial service breach and a lot of things. I believe that I can discuss about it in the Q&A session. So thank you so much for the time. I give it back to my fellow Dananjaya.
Thank you, Miss Jayani, for the amazing presentation. We're now moving on to the next speaker. Allow me to introduce our fourth speaker. She is Miss Alia Yafira Karunian. Ms. Karunian is a researcher in the Institute for Policy Research and Advocacy, well known as ELSAM. She pursued her Bachelor of Law degree in Udayana University, concentrating in public international law. During her college time, she achieved a lot of prestigious achievement. She won the second Best Oralist of National Round of International Humanitarian Law Moot Court Competition in 2016. She achieved the first Best Oralist and second Best Combined Memorial Award in the Philip C. Jessup International Law Moot Court Competition National Round in 2018. She was also awarded as Most Outstanding Student of Faculty of Law, Udayana University in 2017. As a researcher, Ms. Karunian has published many articles which mainly focusing on human rights and technology, also national policy. Without any further ado, it's my great pleasure to introduce our fourth speaker. Please welcome Miss Alia Yovira Karni.
Thanks a lot, Danan, for the
Good.
lovely introduction. Am I audible?
Yes, you are, Miss Karnian.
Thank you so much. Let me screen share my screen. Okay,
Sure.
hang on a second. Okay. Can you see my screen?
Yes.
Okay.
It has been presented.
Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, Shalom Nama Budaya. Good afternoon to everyone. Thank you very much for SCIL and Faculty of Law, Universitas Udayana for having me today. It's a pleasure to be here, albeit online or virtually in Bali, alongside very amazing panelists, Pak Sebastian Lafrance, Pak Budi, and Bella. It's really nice to see familiar faces. This is like this feels the closest thing to home because I cannot go. I'm very much aware as the last speaker, everyone must be exhausted already. So please bear with me. Go grab some drinks, snacks, and go do some stretch, whatever you are comfortable with, while tuning in today. And in these occasions, I will be following up on the explanations, already comprehensive explanations from previous speakers by elaborating more on Indonesian context, on the intersections between cybercrime, data protections, and cybersecurity from human rights point of view. For those who are not familiar with ELSAM yet, we are a human rights organizations based in Jakarta, Indonesia. We do research and policy advocacy on the human rights policies in Indonesia, and I specialize on human rights and technology. So without further ado, I will start the discussions today by elaborating more about the distinctions between cyber-enabled crime and cyber-dependent crime. When we talk about cybercrime, it typically clusters around some categories, two of which I will elaborate more here. The first one is cyber-enabled crime, and the second one is cyber-dependent crime. Everyone can see the definitions and the differences in the presentations, but I would like to underline that cyber-enabled crime basically is the conventional crime that is facilitated by the use of ICT, and the effects, most of the time, the effects are amplified because of the use of internet and communications, electronics during the digital age. So these types of crimes are not only happening in online setting, but also in offline settings, such as online frauds. It also happens during the offline setting. And the second one is the cyber-dependent crime, which the types of crime that requires an ICT infrastructure. And the instances of the cyber-dependent crimes are hacking, ransomware, and attacks on critical national infrastructure, for example. And why is it important to make a differences between cyber-enabled crime and cyber-dependent crime? Because each types requires a different kind of approach and different kind of human rights analysis that I will elaborate further on in this presentation. And now I will talk a little bit more on our cybercrime laws. Indonesia currently does not have a cybercrime or cybersecurity specific laws. We have several sectoral laws regulating about cybercrimes in Indonesia, but I will now elaborate more on the ITE law, cybercrime regulations that is not only regulating about cybercrimes, but also on transactions, electronic providers, for example. And the problem around ITE law enforcement in Indonesia. And from ITE law, we can see that there is a distinction, regulations between cyber-enabled crime that we can found in Article 27, Article 28, Article 29 and Article 40 of the ITE law, and also the cyber-dependent crime, Article 30, Article 31, 32, and 35. And ITE law remains the primary cybercrime regulation, and this is following up on the explanations that Pak Budi and Pak Sebastian have already raised before, that even though Indonesia did not ratify the Budapest Convention, our ITE law is actually largely in line with the Budapest Convention on cybercrime, especially on Chapter 2 of the Budapest Convention. Now moving on to how about the challenges on the ITE law enforcement in Indonesia. There are at least three major problems in the way that the Indonesian government and the law enforcement here enforce those cyber-enabled crime and cyber-dependent crimes articles. The first one is the over-criminalizations of the cyber-enabled crime articles. This is people in Indonesia have been really familiar with how the ITE law is regarded as the Undang-Undang Karet, or vague law that is far from the international human rights law restriction standards, which is widely known as the three-part test. The second problem is that Indonesia is yet to decriminalize defamations. And these articles, unfortunately, are oftentimes abused to silence dissent, critics, even victims of gender-based online violence in Indonesia. And on the other hand, the cyber-dependent crimes articles, which have the potential to be enforced for data theft or data breach, are rarely enforced. And even during times where these articles are actually enforced from data protection point of view or human rights point of view, there is another piece of puzzle that is missing from Indonesia regulatory framework, which is the data protections point of view, which imposes data controller, which is the government, public institutions, and private sectors with certain obligations in order to enhance or make sure that the data is secure. And this is actually comes back to the fact that Indonesia currently has no comprehensive data protection law. We have a pending long-awaited data protection bill, RUU Pelindungan Data Pribadi. However, the discussions of the bill is facing deadlock last July 2021 due to disagreements over an independent data protections authority in Indonesia. And this situation has left Indonesia with over 46 sectoral laws and regulations regulating data protections in Indonesia, which oftentimes overlaps or even contradicts with each other. And I will now go into the implications of this sectoral approach on data protections in Indonesia. Because apart from the cybercrime aspect, data theft or data breach also give rise to the responsibility or the obligations of data controller, which normally can be found on data protections laws. And none of the existing current sectoral laws and regulations provide a clear and adequate obligations and responsibilities of data controller. For instance, ensuring the security of data that they are processing or storing by implementing, let's say, adequate technical and organizational measures, conducting auditing, system auditing in order to make sure the cybersecurity of their system. And also there are other obligations such as implementing privacy by design and by default. Also, and this is in relation to the problems that Bella has mentioned earlier about in times where data breach are happening, data controller actually ideally has the obligations to report to an independent designated data protection authority and inform that what kind of measures that they have took in order to mitigate those incidents to happen in the future, and also an obligations to us as a data subject to be provided some sort of notifications that our data is breached. And none of these obligations, even though the government regulations number 71 to year of 2019 that Bala mentioned earlier, PPPST, already provided the data control with the obligation to notify us as the data subjects. These articles are never enforced. We never received notifications with regard to data breach happening. And this is actually related to the second problem, which is the cherry picking of data breach cases handling and investigation process in Indonesia. Bella mentioned earlier that BES as a national cyber and crypto agency is actually a leading ministry or government agencies that is in charge to investigate data breach. And other than BSSN, we have also Ministry of ICT, Kementerian Kominfo. And from this past previous cases in the past 2 years, for instance, we are witnessing that the governments are oftentimes more responsive to private sector's data breach and not to public sector cases like the Dukcapil data breach case mentioned earlier by Bella. So this is creating some sort of double standard situations in which adding more reason as to why we need an independent and not a ministry-based data protections authority in order to ensure the effectiveness of data protections and right to privacy protections in Indonesia, because like what Bella mentioned very briefly earlier, that it has a very great implications to us as a data subject. There are reports that illegal financial technology applications or companies, pinjol, are building their user base based on data breach or data obtained from the dark web as a result of a data breach. And also, not only that it affects our individuals individually, but also for state, as it is reported that in 2014 in South Korea, for example, there is a huge data breach cases that led the governments of South Korea to reconsider or considering to handing out new identity card to every citizens there, resulting in state loss millions of US dollar. And so we are saying that the data breach has an implication not only to individuals, but also to state. And also there is the third problem is already elaborated, that there is an unclear data breach notification enforcement to data subjects. And lastly, unclear driven mechanism for data subjects as victims. This is closely related to the Tokopedia data breach lawsuits, because leaving data breach resolutions to existing mechanisms such as court systems and civil procedure would have put us as data subject in a very difficult position, because we are left with a very high burden of proof to prove that there is an actually a breach of data from the computer systems of the data controller or the companies or the governments, which is happening within the invisible layer of the internet. And us as a people, like masyarakat umum, do not have the technical capabilities to know that exactly that the breach is resulting from the computer systems, for example. So this would put us in a very difficult situations, and a data protections authority, an independent one especially, will help us to achieve a more effective protection for data protections in Indonesia. And now we are moving to the differences between cybercrime and cybersecurity. Dana, please feel free to stop me if I go over time. Now that we kind of already established that when data breach happen, there are two angles to look at the case. One of which is from cybercrime point of view, which is punishing the hackers or the unauthorized access, and also from cybersecurity point of view, which is implementing preventive measures and making sure to fix those vulnerabilities to mitigate future harm. However, despite the different concepts between cybercrime and cybersecurity in Indonesia and many other countries in Southeast Asia, for example, the term cybersecurity and cybercrimes are often used interchangeably, and it has shaped how countries are approaching or regulatory approach to cybercrime and cybersecurity. So the trend is they are regulating both cybercrime and cybersecurity in one piece of legislation, which raises a very hating concerns for its potential abuse by the government. And I would like to cite Thailand as one of the instances which passed a very controversial cybersecurity act on last 2019. And how about Indonesia? Now, going more on the Indonesian context, we had a cybersecurity and resilience bill last 2019, and there are several challenges around how this bill is being drafted and discussed and almost passed on 2019. The first one is lack of public participation. So the draft of the Indonesian Cybersecurity and Resilience Bill was firstly made public on August 2019 and was rushed without proper public consultations and participation from the public, and was initially planned to be passed on the next month that same year, so September 2019. And all of this were happening around the same time of the nationwide demonstrations against the revisions of anti-corruption law, revisi Undang-Undang KPK, and also against our new penal code draft that was highly controversial on 2019. So in a nutshell, the bill makes BSSN a superpower agency by extending its powers to include censorship and surveillance problems that I will, maybe I'm not going to elaborate more on this, but I will like to mention that also are problematic articles in the RUU KKS bill. So to briefly touch on the state-centric definitions to give an overview how this cybersecurity bill is actually drafted in a way that is state-centric. I would like to give an example that the definitions of cybersecurity, for example, or the definition of cyber attacks are really similar with our national security bill and also our state intelligence law. So this actually puts, okay, so actually I'm displaying the wrong slides, but the state-centric definitions is actually the problems on the Indonesian cybersecurity and resilience bill. And to just go back, I'm so sorry, I'm not aware that I displayed the wrong slides. And this is actually comes back to the very problems about the approach the many governments are taking on regulating cybersecurity all around the world, which is state-centric and human-centric approach. So I will start by the definitions of state-centric approach, which places sovereign state as the principal object of security, and therefore oftentimes these regulations delegate responsibility for the security of cyberspace to states' national security apparatus, which oftentimes operates with the lack of accountability, oversight, and transparency. And though it dominates the conversations in Western democracies, the state-centric approach actually is most compatible with authoritarian regimes and liberal practices. And on the other hand, this human-centric approach actually places human beings as the primary objects of cybersecurity. And it means that the human-centric approach is securing individuals' security, which go hand in hand with human rights protections. And Pak Budi and Pak Sebastian already mentioned earlier about the importance of integrating how international law is applicable to cyberspace. And I would like to also provide several instances in which the integrations of human rights principle or international human rights standards to cybersecurity approaches has been affirmed through various international law instruments, one of which is the UNJ resolutions number 68 number 198, which was adopted back in 2013. And the human-centric approach actually poses a very important question, that who should be the ultimate beneficiary of international law? Is it sovereign states or the individuals that make up those sovereign states? And
What?
humans.
Ms. Karunian, my apology, but your time is up to present your presentation.
Great, Danan. Thank you very much. I will just finish my sentences and then close my presentation.
Sure.
And then the human-centric approach actually falls on the later perspective, which international rule of law in which cybersecurity laws, for example, ought to benefit individuals in priority, and sovereign states are agents of that entitlement. So in a nutshell, security for one is security for all. Okay, I think that's my last presentations. Thank you very much. I will looking forward to discussions in the Q&A session. Thank you very much, Danan. Over to you.
Thank you very much, Ms. Karunian, for the amazing presentation that you have presented to us. Ms. Karunian presentation is the last presentation in this seminar. With that, we are now proceeding to the Q&A session. The same as the previous Q&A session, participants are allowed to and encouraged to ask questions to our speaker, my apology. And I will be reading some of the questions that have been submitted and addressed to our speakers. So for the first question is coming from Anonymous. They ask Ms. Karunian for how the protection of human rights on the internet apply when there is no relation to this cybercrime. And the second question is coming from Kanita Amaris. She asks, who should be responsible for data theft incident? Is the government, the people, or the people who fill out the digital form, or the related e-commerce provider? Is that clear? My apology. I will read that again. Who should be responsible for data theft incident? Is the government, the people who fill out digital form, or the related e-commerce provider? Those are the questions for Ms. Karunian. For Ms. Karunian, it's your chance to respond to the questions.
Thank you, Danan. So the first question is how human rights are applied to cybercrime articles enforcement in Indonesia. And I talked about this earlier on the presentations about how our current status quo is that the ITE law there is a huge discrepancy between the enforcement of the cyber-enabled crime and cyber-dependent crime articles enshrined in ITE law. And the problems of the over enforcement of the cyber-enabled crime in Indonesia is that these articles are not applied and enforced in a manner that is consistent with international human rights law standards, especially the human rights restrictions standards that is enshrined in Article 93 of the ICCPR, which collectively known as the three-part test human rights restrictions, in which Indonesia already ratified to law number 12, year of 2005, if I'm not mistaken. So how are these articles related to the human rights, the three-part test standards, for instance? So I would like to explain on the three-part test first, that it actually consists of, like the name of the test, it consists of three requirements. The first thing is that human rights restrictions should be prescribed by law, which means that the law should not be vague and should be drafted in a position that allows us as individuals to manage how we behave in a manner that is not in a violations of those articles. And the second is the restriction should pursue legitimate aim. And lastly, the restriction should be necessary and proportionate in democratic society. And the practice in Indonesia, the enforcement of ITE law, the problem is always that the law is vague. Apart from the fact that we still have criminal defamations, which is in contravention of international human rights law standards, because it is not proportionate and necessary, because it creates more chilling effect to us as citizens. So the Human Rights Council, for example, and committee has been underlining that that defamations article should only follow the procedure of civil law and not a criminal law. And lastly, to make it more concrete example, I would like to point out a recent case, I must say, Bapak Saiful Mahdi. If teman-teman familiar with the case, he's a lecturer from University of Siakwala that was accused of defaming the faculty of engineering in University of Siakwala, which is problematic because defamation cannot be applicable to public institutions and only can be applicable to individuals. So this is actually the kind of problems. There are other problems surrounding the enforcement of ITE law, and this is why we need a very adequate understanding both for the law enforcement as well as the judge and the prosecutor in Indonesia in order to integrate how international human rights law standards are applicable to ITE law articles enforcement. And the second, moving on to the second question, which is who is responsible when it comes to data breach incidents in Indonesia? And the answer is actually when the data breach happen, there are two angles that can be taken in viewing the case. I briefly explained about this earlier, that it actually gave rise to the individual or criminal responsibility, not criminal responsibility, but punishing the unauthorized access means that we can criminalize the hacker, for example. But also on the other hand, there is also the responsibility of the data controller, which includes the government. If the data breach is happening to the public agencies, let's say Ministry of Home Affairs data breach that Bella explained earlier, or even private companies. And this is closely related to how the data protections bill in Indonesia and around the world, the material scope of data protections laws, not only applicable to private sectors, but also to public sectors as well, which includes the government. So when the data breach happened, it means that the government as a data controller also is responsible to, in order to prove that they are already implementing adequate data security mechanism or safeguards that that prevent them to be responsible for data breach. Does that make sense? I mean that if they are already making sure that they already implemented all the adequate security preventive measures, then they are cannot be held responsible. But if there is a missing adequate safeguards, they can be held responsible for that as well. And this can only be implemented or assessed if the data protections authority and independent is independent. I mean, so they are not within the Ministry of ICT, for example, because what if the Ministry of ICT themselves is the one that is breaching the data? It would create concerns over conflict of interest, obviously, and would result in not effective data protections and right to privacy protections in Indonesia. I think that's all from me, Danan. Over to you. I hope that answered the question.
Thank you, Ms. Karunian, for the answer. Now I will read the question. They are addressed to Ms. Jahani. There are two questions that are addressed to Ms. Jahani in the similar topic, which is how then the young generation deal with such threat, such the things that have been presented by Ms. Jahani before, as how the data breach have happened in Indonesia in so many times. For Ms. Jahani, it's now your chance to give the response to the question.
Okay, thank you, Dhananjaya. I would like to firstly confirm regarding the question. So the question is how the young generation deal with cyber threats and how to prevent it. Is that correct?
Yes, it's correct.
Okay, so I would like to point out that previously I have mentioned that several data breach, even a large data breach that have happened in Indonesia, basically amount to unfinished settlement. So all we need to do is to build the awareness within ourselves, like to give protection in our personal data. So it needs to be started with ourselves first, especially we as the young generations who are aware of the increase of the technology digitization. So I would like to highlight several points that we can do as a young generation in order to protect our personal data so that we can prevent our data to be stolen by the hackers. So as the young generations, I believe that most of you are using social media, so we can start from building a stronger password in our social media. So please do not use your name or do not use your parents' name or even your birth date as your password, because it can be easily tracked by the hacker, especially if our identity has been stolen by the hacker. So please build a stronger password on every social media that you are using. And then the second one, we can enable double authenticity in every social media that we are using, and we can be very careful in receiving any calls, especially from an unknown number, in which it can amount to the scam. Usually the hacker will try to offer any gifts for us, and then in order to receive our personal data protection. So be careful if we receive any calls from an unknown number. It may lead to a scam starting with gift offerings. And then if we signing up to an application, we often required to put the OTP that were sent to our phone number and or even to our SMS or email. So don't ever put that OTP to any other person because it can also lead to data breach. So make sure that that OTP only known by you. And then what I want to highlight again is sorry, I think the host muted me. Okay. Okay, is my voice is audible right now? Oh, okay.
Yes, you are audible, Ms. Jahani.
Okay, so I would like to highlight that I believe that most of us are also using WhatsApp, right? And we have a lot of WhatsApp group that some of the people in the groups are not aware to send the link that offers any free quota or any free scholarships that if we click the link, it often requires us to put our personal data like email, phone number, and name our name. So make sure that the link is official in nature. So make sure that you guys double check the link first prior to entering your personal data by clicking the link. So it can prevent our personal data to be stolen as well. So the thing is, the thing that I want to highlight is building the awareness that our personal data is very important for us. Oh yeah, and one more point, we often have the thought that we need to upload any like vaccinate vaccine card or any rapid test result that contains our personal data as well. So I urge all of the young generations to not upload that on social media because it contains our name and then it contains our birth date and other personal data that may be easily stolen by the thief. So make sure that you guys really filtering what you guys upload in social media, really filter what you guys click from WhatsApp group or any other social media. Make sure that it is official in nature. So I think that's all for my answer. I hope that it answered your question to the one who asked about that. Thank you so much. I give it back to my fellow Dananjaya.
Thank you, Ms. Jayani, for the answers. That question marked the end of our discussion session. Now, each of our speakers has the chance to give a closing statement. I'd like to firstly give the screen to Ms. Jayani.
Okay, so if I may be honest, I haven't prepared any closing statements. So I would just like to say big thank you to SIL for holding this event. Basically, it is me as the president of SIL. I would like to say thank you to all of the speakers that have given their time to attend this SIL International Seminar and to all of the committee board that has also given their dedication in holding this international seminar. And I would like to highlight that as a young generation, we need to build our awareness in protecting our personal data. And you can use our my tips that I have mentioned earlier. And then please always aware of what is going on the social media, on the cyberspace as well, because more trends, more threats. So I hope that you guys will be very careful in following these trends that are currently happening during this COVID-19 pandemic. And I also would like pardon me, I also would like to apologize for any mistake or any inconvenience that might appear during my presentation or during this SIL International Seminar. That's all from me. Thank you so much. And I give it back to Dananjaya.
Thank you, Ms. Jayani, for the closing statement. Now, I'd like to give the screen to Ms. Karunian to deliver her closing statement.
Thanks, Danan. And anyway, Bala, you made no mistake. You're doing very amazing. I will be really brief on this. I'd like to say that I'm really grateful and excited that student community of international law and faculty of law, Universitas Udayana, obviously, are starting the discussions around law, international law, human rights, and technology. And so this is a really area in which Indonesia is a very less regulated area, much less studied. So it's really interesting and exciting discussions today to hear from international law perspective on this topic. And I think the question is what's next, and that is the a very hard questions. And Indonesia surely still has a very long way to go, and it's gonna be an uphill battle on this. But in a nutshell, I believe that Indonesia has to firstly fix the misunderstanding around cybercrime and cybersecurity, and adopting a human-centric or human rights-based approach, not only in the cybersecurity areas, but also in cybercrime and data protections, and focusing more on protecting the individuals and creating an environment of regulations and enforcement of that regulations in a manner that is consistent. I'm so sorry, to human rights law standards. I think that's all from me, Danan. Thank you very much, and I hope that everyone here is staying safe and healthy amidst this very hard times. Over to you, Danan.
Thank you so much, Ms. Carolian, for the closing statement. From the sharing session and discussion session previously, we can conclude that the trends that are happening right now, especially in Indonesian and millennial, are very dependent upon e-commerce, transportation based on online foods, online travel, online education, and many other things that based on online. Hundreds million cyber attacks have occurred in this previous year, especially in this pandemic situation. The trends rising, and that potentially rises a threat for the cyber attacks. Many cases covering Tokopedia, Regulation and Civil Registry Office, Indonesia Healthcare and Social Security, and Very Ill Life are some of the example of how these potential threat is really happening and is really threatening all of us. Even though Indonesia have the existing law, but it isn't strong yet and not implemented well in Indonesia. The major problem of the ITE law that have regulated by Indonesian government is first over criminalization of the cyber-enabled crime articles. Indonesia is yet to decriminalize defamation, and cyber-dependent crimes are really enforced. It also raises challenges. There are unclear data controller obligation and responsibilities, cherry picking of data breach allegation, unclear data breach notification enforcement to data subjects, unclear grievance mechanism for data subject as victims, and many other things. Indonesia is also messed up in using the term cybercrime and cybersecurity as how it is actually a different terminology and for different circumstance. The Indonesian law is also more state-centric rather than human-centric, and that raises a problem too. Restriction should be prescribed by law, should pursue legitimate aim and proportionate and necessary. And one thing that I want to quote that have been stated earlier by Ms. Karunian, that is very true and very strong message for all of us, that security for one is security for all. That's all that we can conclude. Now it's time to photo session. For all the participants who haven't turned their camera, please turn on your camera and show your best pose. And for the concerned committee, please take a good picture of us. I will count. For the first slide, 3, 2, 1. For the second slide, 3, 2, 1. For the third slide, which is the last slide that shows the participants who are on camera, 3, 2, 1. All right, the photo session marked the end of our international seminar in this day. I hope all participants acquire benefits, knowledge, and insight from the speaker that have presented amazing materials from the beginning of the first part of the sharing session. Lastly, I want to say goodbye, see you in another occasion, and have a nice day. I'll give back to the MC, my friend Damaro.
I would like to thank once again all of our magnificent speakers today for their lectures and participation. Also, I would like to thank Dan and Jaya, who becomes the moderator of this event. I would like to remind all of the participants to fill the absent form on the chat room. I will give you 3 minutes to fill the absent form. Thank you. And while we're waiting for the participants to fill the absent form, for the speakers and all distinguished guests, if you have other agendas, you may leave the room. Thank you. This will be the end of today's session, and I hope this seminar will give you new knowledge and perspectives of data theft and cybercrime in international law perspective. Thank you to all of the distinguished invitees and attendees. Have a nice day. We are reminding for the participants that you will be informed concerning the certificate through your email and online group. Thank you for your attention, and you are now allowed to leave the room. See you in the next session of SEIL events. Student Community for International Law, we are smart and law provide.